Hi everyone. Today we have with us team consisting of Yash Bhandari, Vedant Upadhyay, and Niharika Gupta, who have secured the runners-up position at the 21st Surana and Surana National Corporate Law Moot Court Competition 2024. Firstly, many congratulations team for the amazing success in this prestigious competition. Before we begin talking about your journey, I request you to please introduce yourselves to the audience.
Thank you, Niharika, for such a warm welcome. Now, we do not carry such big laurels to be having a broad introduction. I will keep it very precise. My name is Yash. I am currently in my third year of 5-year course in Government Law College, Mumbai. Throughout my journey within this law school, I have always been tried to participate in such public conferences, may that be moots, ADI competitions, or events so that to make me active in this all such things. My other teammates would be much more in depth to decide for themselves.
Hi Niharika, I am Niharika Gupta. I am also in Government Law College with Yash. I am in my third year. So to add on to what Yash said, even I have been consistent with many of the competitions like ADRs or moot court competitions. But yes, that's all about it.
Hi, Niharika. Thanks for the warm welcome. I'm Vedant, and I'm a bachelorette of Niharika and Yash. And I also study in the government law college itself. And honestly, I have also tried to, I have also actually did a lot of competitions here and there with respect to moves and everything. And everything what I am learning and doing right now has been having an impact. Thank you.
Right. To start off the discussion, can you tell us about the structure of this competition and about your team composition?
So we had a prelim round. We had two prelim rounds in which we need to present from both the sides. Forwarding this, we used to have octa-finals, but because this time the team was not in that limit to have octa-finals, so we directly have quarter-finals. When we succeed quarter-finals, we have semis and then the final rounds. The team composition was in right. I was a researcher, and these two were the counsels.
Right. Preparing for a moot must definitely be a long journey considering the complexity of the problem in hand. Can you break it down for us in terms of preparation? So what can you tell us about the research strategy and your presentation strategy?
So that's something that even we thought of discussing. Now, when we talk of even research or something that we were not. So this mood was allotted to us back in June, July of the last year.
2023, yes.
2023, the normal qualifiers that every college has. We prepared for it, but that to be honest, we started our main preparation in March 2nd or 3rd onwards, and our submission was in March 10th. So that's how we started our preparation. Precisely before this, we had enough reading of the fact sheet that we have to understand the term because it was involving cross-border taxation and other corporate laws to know basics of it so that we could incorporate what things are we reading on. But our main preparation started just after we all have finished our internship in Feb, and then we started in the 2nd or 3rd of March to submit our memorials. We will try to break down our things into 2 or 3 parts. That is like how what all we did before submitting the memorials, how we researched and drafted the memorials, what all we did in the period between those before the oral rounds and the memorials, and then how we presented ourselves in the oral rounds. So to be precise in this format that we just had one thing in our mind that we had 6 issues and we tried to divide our 6 issues into various parts, but all those 6 issues were not something interrelated to each other, whether they were like having distinct attitudes to each one of them. Now with the division in hand, we used like one thing which we had thought of, that anytime when we discuss something new, we had like separate groups to discuss. We will like pitch in those groups whichever ideas we have, because this mood was always evolving on cross-border taxation, and we three have not studied tax in our law school yet. And this is like 4th year, it was an optional subject for us. So something new, whichever thing we discovered on any of the law portals, we used to submit to each other and discuss with each other. So that's how we tried in binding information to each other, because anytime the question can be pitched to any one of us. So if anything, Vedant and Niharika want to add to it, and then we will move forward.
To add on to what Yash said, this mood was definitely something which was new to us, the topic itself. So it was around secondment arrangements, right? And 3 of us were clueless what it is. So starting from what a secondment arrangement is, firstly, and how different laws are applicable to it was something that the 3 of us had to research. A lot on it.
honestly, I still remember Yash and I were sitting once, and Niharika was also there. Yes, she was also there. We were having a reading of the prop, though we had already read it for, I guess, not less than 4 5 times. Still, we got something new in that. And okay, this we can use in our favor. This goes against us. So that's every time we were actually reading through the prop, we got something or the other different, and we had the prop actually had a very wide interpretation. So that was actually a challenge for us because once we thought we are settled, but again we came with the crop came with something new and a very different idea from what we actually thought of. So that was something which was fun also to do. So yes, that's how it is.
Right.
So adding to this whole thing, now one thing that we found that while we like this is what while we are making our arguments to summarize like what we will give in the memorials, we had one thing in mind that we will not settle out with one argument that we have, howsoever big or howsoever strong it will be. Because anytime if that argument fails, then we our whole issue that tends towards the other side. So whichever side we are representing, we need to have at least 3 to 4 arguments to subset our things. So that whenever we move forward, we have enough resources to subside with it. Now, while we started our like research was going on continuously, we had enough case laws because it was around six issues involving it. And to be in that part, then we will have one more issue to be discussed. To be like to make a new factor for other teams, we will have 7 issues to be discussed. But there's 7 issues involving so many case laws. So we started to bend down our research. We started to like draft. We had enough like started up preliminary drafted with each of the issue. Then we tried to combine it and again filtered or what arguments to be pasted on. So if to be said at how we move on with research, that one thing to be taught is that SEC Manupatra is one factor that you always have, always rely on the like read the case law to be the fullest. Sometimes initial part would be in support of you and a later part just oppose the whole view. But again, in the same part, when such issues like this secondment is still an arguable issue when it comes to GST, whether it's been following into it. So you need to look on what research, what other experts have the view on it. Maybe sometimes various law firms have their own views, what they carry forward. Experts have some portals or government portals have their experts view. So you need to read an whole angle with it. So that's how we started reading and we started drafting our memorials per se with it. But then even drafting carried a long because we just have 7 8 days in a hand and draft the whole thing. And even at that time, we had followed up. Our schedule was so busy that one of our member had competition just after submission of the memorials. We had our exams, like internals being some sort of interns going on just after it. So our things were very packed up. But we thought we have time till 1 week. Let's divide in that order and move forward with it. Yeah, please add, guys.
Right. To the speakers, if you could elaborate more on your presentation strategy.
Presentation actually, see, what my take here is that the attitude and the intent mattered the most, to my opinion. When I was the speaker one always, so I had to deal with the issue of the admissibility of the writ and everything. It was a writ petition in the High Court. So basically, I both of us, Yash and I, used to see each other, and he was like, so we just used to stay silent and we used to look at each other, and we knew that, nahi, this is the game plan. We have done it already, and we know. Just believe in us, and we just went. And this happened every time. We had no script, nothing. Both Niharika and I never had a script, never kept a script, and we just jotted down the points that we had to speak, and it was always impromptu, whatever we spoke. And because and always, personally, I'm of the opinion that one shouldn't enter the courtroom with the mindset of arguing. It's always assistance to the court. So if you enter the court with that mindset, it's always like, okay, fine. It's more like you automatically become very calm, and then you are able to function better. And what really happens is that you are able to point out the facts, or for that matter, from the fact sheet, or for that matter, any part of the judgment which you want to invite the court's attention at. So you can really do that well, and that actually matters a lot. This shows the clarity that you have, and the depth in research and drafting whatever you have done. It actually shows that you have actually invested a lot of time in doing whatever you are doing, because you all of us know that law is not an easy forte, right? So it takes time, it takes effort, it takes energy, everything it takes. But yes, at the end of it, it's worth it's worth doing whatever you are doing.
Right,
Niharika?
and to add on to what Vedant said, we did prepare speeches, but we realized before the rounds, like a day or two before the rounds, that these speeches are too, like, this is not something that we can go forward with. So we jotted down all the pointers and we made sure that we're not reading the speech. Also, during the rounds, our other teams were also instructed not to read out from the memorials or from the speeches. So that is where we did gain a brownie point.
Right. As and when you progress to subsequent rounds, your approach changes according to the feedback that you get from the judges. So, how did your approach to preparing for the subsequent rounds change from the one that you went to the competition with?
Uh,
So,
I
just
actually have a very small story to narrate.
uh,
It's between Yash and I. So what really happened was, we were having tea, and then we were discussing that okay, this judge has put this particular judge has said this way, and everything is this. So we actually tried to understand what exactly the judge wanted from our prelim one. So we had two prelims. We knew that okay, we are going to the quarterfinals. So we were having a very critical analysis of the feedback as to because now we had critical analysis of almost feedbacks of almost four judges. So we actually sat down and we thought, what actually is the intent? How are they thinking of it? So it was really fun and it actually mattered the most because we inculcated all the feedbacks and everything in our submissions, whichever the oral submissions we made. And there were times when we didn't have something in the memorial, but we had it in our oral submissions, right? So it actually evolved with time. So whosoever is entering a moot court competition thinking that a particular strict or stringent straitjacket speech would work, it's not going to work at all, for sure. This is something I can say with my experience. So that the evolution of speech is very important because it is only then that, and you listen to what the other party has to say. So what they bring to the table, so that there might be cases that they might be having something very different from what your line of thought might have been at the time of drafting the memorial, because you follow the same line of thought everywhere, right? Till the time of your oral submissions. If you get something new, and it's always very good to inculcate that and to admit that in your submissions. That is how we evolved. That is how we practice. Niharika?
okay. So just to add to what Vedant talked about. Now, even when we had all the feedbacks, but every time when we got the feedback, there's something different that we have. So even one thing that we noticed that one feedback is very common, that you do not need to rely on the what part of your for example, we have the whole issue. You don't stick to the whole issue. It maybe they will tend to narrow the whole issue to such a bottom point that they will discuss how GST and how basics of GST will be around you. So at that time, you need to know which act you're discussing and how important or how they have been involved. So at this point, the GST was very important at that picture. The second thing to this, that while we are progressing to new and fresh rounds that we have, we always have one thing in mind, that we need to somehow show those factors which other team do not have. One is to counter other team, that is for sure, that is on any point that they have. Second is to at least show the judge that we have researched to that extent, we have some new points which no one has, and that is that we all research in that manner in the progressive rounds.
To supplement what Yash said, so giving examples from the round itself, Yash had actually found out whether the composition of GStat has been done yet or it has not been, and whether there are any vacancy notices to such effect also. So that is one point. And even one of the questions of the judges was, how is a show cause notice even issued, or what are the stages of it? And I think these are things that maybe a few teams did not prepare with, or something that not all the teams look at. So it is with that detailing, or even one of the questions was valuation of supply, or that is something that was just a single line in the moot proposition, but the judges went on detail, like on some detailed questions on such issues. So it's very important to see each and every line or research upon it.
Right. Can you share
So
any?
that I
Sorry.
remember.
Yes. Sorry.
Oh, I'm sorry.
No,
From
go.
that, I remember one aspect again. It was after the first or second reading of the prop. I was having a voice with Yash. So what really happened? He was talking about Finance Act of 1994. Though our problem was entirely based upon GST Act 2017, CGST and everything, as CGST Act and the council and everything was very good. So the point was that he was talking about about the fact that the Finance Act of 1994 says this. Manka, why are you worried so much about this? So like, I think we'll have to study that. Manka, why? So he said that no, see, they have talked about Finance Act of 1994, and I believe that we'll get something or the other from that. So it was really honest. And what really happened in the very first prelims itself, the first question that was thrown at me was with regard to the Finance Act of 1994. They actually, the judges tried to understand whether we understood the comparison between the Finance Act of 1994 and the GST Act, as in the entire idea of GST of 2017 or not. So that was the very first question that they had for us. And there are certain definitions which not many people would have done, I'm sure, our competitors. We took as in what we did was we carefully considered the EPF Act and everything. We looked for the definitions of employees because we wanted a legal definition of employee or something of that sort. So we always, whatever we wanted, we never relied on a concept that this is the prevailing notion. We always wanted something there in the statute. If there is something in the statute, nothing better than that you can have to present, because it makes your argument stronger. It makes you feel more confident because no, see, this is the statute I have by my side, and I can rely upon the same. So, which because no one is above the law, right? So they will also consider the same. That is how we actually gained confidence. That is how we learned and we evolved.
So just to add to this, that now we all are like one thing which I just recollect that we all have interned a long while for 2 years, and how our presentation draws to us is like looking at our seniors. And we all traveled to courts multiple times, looked at how they have drafted, how they are speaking, and all our presentation delivered a similar manner. Like how they used to back their things, how they have been known to what origin that they are discussing, and that's how we carry forward our preparation to the moot.
How
Right.
we learned what assistance to court is, right?
Yeah.
Actually, we learn court craft simply there itself. In the High Court itself, or for that matter, in the City Civil Court as well. We get to learn the court craft as which particular point is to be presented first and which to be presented at the secondary level, or if at all we don't have to present anything, even though it's there in our memory. So
When to
that's
stay
how it really
silent.
happens.
Yeah.
Yes, when to stay silent.
Very important.
That's important. That's very important.
Absolutely.
So we should know when to step in and when to back off. And it happens in a fraction of a second, because if a question is thrown at you, or for that matter, circumstance is such, and you are in pressure. So there are times when we have a slip of tongue, but we have to control this in that particular manner at that moment, and that is how it really worked out, and that played a very instrumental role, to my opinion. That we looked at our seniors multiple times arguing, and not just one senior. There are many senior accounts here in the Honorable Bombay High Court. We closely observe them, and then that's how we learn as to how to speak it and everything.
Works of living in Bombay. Right. So,
Indeed.
beyond legal arguments, what non-traditional skills or approaches do you believe were crucial to your success in this competition? So, you mentioned various things that your competitors did not do, which you do. So, you did. So, what other things that you can point at?
So just to point out that very initial thing that we have, that we anytime when we go to court, we have that has been we mentioned multiple times. We only had attitude and we will assist the court. We are not coming to argue. We are not coming to debate. We are just coming to present the point most humble, kind manner that we have. And this is what we have even learned, that even judge pointed out one of the round that we were going on, that he tried to grill us in a manner that we somehow shackled up. We somehow increase something, a pitch or something. But then he realized that he even commented on his after the round that you had maintained your pace, you were very calm and composed. And even that time, when what we think is when we are calm and composed, we can deliver something with the impromptu things that we have. So that thing to be the priority that we carry on. Secondly, that always have a that one thing that we thought that this all areas are for connections only. You connect to so many law schools, you connect to so many organizing committee members that might assist you in whichever, even during the rounds or even after the in your legal faculty, legal field, wherever you are. So that thing we realize that connection is one of the key criteria that we need to move on with. Vedant, Niharika, please supplement it.
Adding
Just
to
one
Yash,
instance.
I think one of the skills that one should have is reading the room. It is very important
Yes,
whether the judges are ready
absolutely.
to extend your time or
Right.
they are interested in listening to you is something that one should know. So you can adjust your time according to that.
Absolutely.
That's really is the thing, because there are judges who actually want to listen to what you are saying, all law points. and there are judges who actually watch the watch. So they keep a check on the watch as to whether they are done with their 30 minutes or whatever. So it totally depends. And one of the taking actually what Yash said reminds me of one of the instances. I was one of the competitions before, and his friend, that particular person whom I met in the other competition, his friend came to Surana. So we met, and I think he was briefed before about whether I was going or something of that sort. He somehow got to know through my Instagram stories or something. So he came to me and he was like, so and so person. I said, yes, I know him. So like, he's my batchmate and he speaks highly of you. You had a good time in that particular competition. Okay, yes, yes, it really happened that way. So it went that way. So this is where connection really matters, and it actually helps you develop more connection. So that's how I think what Yash said actually is good sport.
Okay. Lastly, what one learning that you take back home, and what advice would you like to give to law students who are aspiring to participate in such competitions?
I will start with the learning part. So I think having a good team is very important. A team that stands by you, whatever the situation is. So I think Yash and Vedant, both of them were very supportive throughout the journey. So I think, yes, having a good team is very important.
Probably
So,
this is for
Yash,
the
you
first time she's admitting this.
sorry.
This is for the first time you are admitting this. Thank you, by the way.
so like, just to add to this, like team is first of all the three criteria whenever any type of competition that you go forward to, and that too for a Moot, because it's not a one-day thing. It's like it involves your sleepless nights, it involves your hard work, so it requires a team support, to be honest. Now, adding to this, that we all realize one thing, that like for everyone who is watching this, that you always everyone will have the same problem, everyone will have the same fact sheet, and difficulty level will be equal for everyone. So you do not need to relate that it's difficult, it's not possible for me to do it at the amount of time that we have. It's something that even I can do it, and the dedication that you carry on. The secondly, which I want to say, is that always have something new that no one has. Like, we had read the mood problems so many times that we could identify that this point of fact is so subjective to us. This is completely again this, which I guess no one would have had at that time, or even for the reports or vacancy notices that we supplemented. So all those things add to it. We even try to make it so practical that we even tender a list of dates and events to make it so practical and make something like we are in a mood court. So those are things that many teams were not prepared to do it, but you had something new to present always. So that's for sure. And lastly, that connection that goes always, that we had a good connection with the OC organizing committee members, and we had, even when we require the support that is then required for logistical issues or
Urgent
statement issues.
printouts, right?
Yeah, and that was time that we have various stories related to it. But that was a time when we found that our connection with the organs committee was so healthy and so helpful, that wherever we felt difficulty with related to logistical issues, they were the people who always supported us. Vedant.
So yes, so the point is that at the end of it, it is about the issue that you, as in issue on which the prop is based, you take a bird's eye perspective of the same. Because honestly, I feel that you get to hear a lot of opinions from different people from different parts of the country, right? So the thought process, what they are taking in and what you are taking is can be different, and it is different always, of course. So it really gives a bird's eye perspective as to how this can really function, and ultimately it scales down to a solution as to if this problem persists in practical. So this can really help us. And honestly, this time what we were discussing also once, that the issue of secondment is very real, and and there is no concrete judgment with respect to that right now, because it is a controversial topic, and it has a lot of interpretation. So there are times when people actually think and they take our argument for, and they actually, because people who judge us are the senior counsels and they are judges as well. So, and the administrative and the people who are involved in CAs and everyone. So basically, they can take an agreement, they can take a argument which you must have put forth, you must have submitted, and you never know that a judgment could come. So one should always take most very seriously, because it involves actually a greater good, and it can have a bigger picture as well, not just restricted to a particular field, or for that matter, for that those 2 3 days where you are going to argue. And it actually gives you an enhanced confidence, to my opinion, because arguing in the finals, we argued before a 5 judge bench. Everyone convincing each and every judge was quite difficult for me personally. So but after that, after a while, when I saw the score sheet and the way, because see, you can read the face also if they are satisfied with whatever you have submitted or not. If they are by your side, you're halfway there already. So there were, I could see that no, 2, 3 judges are there who actually are satisfied with whatever I've said. So there are chances that they might not have been the last questions further during the entire session, and that happened with me, with 1 or 2 judges. So you get an enhanced confidence as to whether you can argue before the bench or not, and it was a serious bench of 5 judges. So that's what my take is for.
Also,
Just
to
to
add
add to
on
this.
to, yeah, go
Yeah,
ahead.
Niharika.
Okay, so what I had to add on to what Vedant said was the fact that we also have an open mind to reach out to people who are actually practicing the current papers. So we did reach out to one of our friends' brother who is practicing in indirect taxes. So it was very helpful for us to understand what is the current scenario. He gave us real life examples and he did help us out to to understand what the concept is. So I think even if you don't know anyone, feel free to reach out on LinkedIn or any also. It does add on to your experience.
So just to add to this, that one thing is that you need to, anytime any issue that you have, break it down to so simple, like break it into so simple level that even a normal like, person who's entering law, just know the basics of it, could understand your arguments. So sometimes we know the issue so in depth that we try on making so complex for others to understand, that even if you have so good arguments, we cannot connect with others. So make your argument to so subtle level, so easy, so simple to for everyone to understand. Because when you try to throw arguments, do you just have a couple of minutes to entertain the whole issue, and that the time just spans away, that wanes away if you are not able to supply what other members are demanding to it. So that's all.
All right, team. Thank you for being here. Your insights were incredibly valuable, and I'm very certain our audience will benefit greatly from what you've shared. Thank you once again for your time and generosity in sharing your experience. I, on behalf of ILCC, wish you all the very best for your journey ahead. Thank you again.
Thank you, Niharika.
So thanks a lot. Thank you, Niharika.